about someone living.
That's what I'm trying to find out. This is the first time I've had the transcript. I've got it in my notes on the recorded time.
I got you.
I'm just trying to find that.
I'm with you. All right. So you've never seen that either?
No, sir.
read it.
I'll pass up the transcript to Ms. Walden.
Okay.
And I have a piece of paper with it that are the two areas I'd like you to look at, which indicate that.
But tell us
by
listen,
pages.
also which pages they are, so
This
you'll
is,
have.
line numbers 488 to 508, and then line number in the area of 724, could carry over to 725. Just send them here down.
Take your time. And we'll-
May I provide her with written statement as well, so she's got it updated?
What written statement? Her?
Yeah. Or actually, that would be to my question. I'm sorry.
Right. She has what transcript of what she said. That's what we can.
Am I allowed to ask questions?
You can do this. If you don't understand his question, then you can have it restated. But remember, he's going to ask you questions. The solicitor will ask you questions, so maybe it'll all get cleared up. But
Okay.
technically, you know you're not allowed to ask the question. Okay?
Okay. Thank you.
Have you had a chance to read it?
The party.
The party, and that's
Yep.
all, and that's all I'm asking. All right,
Okay.
hold on just a second. For the purposes of the record, we've looked at the statute. Everyone is in agreement now because she's been provided with a transcript of what was a recorded statement, but it was never transcribed and never signed by her. She now has it. Question and concern the court had is clear that the section 180 deals with examinations of witnesses and of witnesses in a criminal proceeding concerning written statements. This section was written and last amended in 1977. We now have a different technology available, and I don't think that the law intended for witnesses to have to give a recording statement and not then be examined about it and not be able to be questioned without having a chance to hear that. An oral statement, clearly, you don't have to worry about it. If you can say, I don't remember, and you're right, solicitor. With an oral statement, you're correct. I don't recall. That's it. But we have something that was done properly in an investigating a crime where a statement was taken, and we all know why. It's to help the investigating officer, it's to help the witness, it's to help everybody, so that everybody has knowledge of it, much as we have with written statements. I don't think law enforcement or anyone's required to write everything down if they intend to have it used for purposes going forward. Oral statements, we all know the danger of that. Anybody that's involved in law understands that. And so that's why we have a recorded statement. We understand that. But so we have complied now with the existing statute, because this witness, you've had a chance to read those portions. And if she asks you another portion, I'll allow you, we'll make him give you exactly that and give you a chance to read it, okay? Is that okay with you? Okay? Let the record reflect the witness shook her head in agreement with that. All right, let's bring in, we ready to continue?
Yes, Your Honor.
All right, good. Thank you all. Appreciate your patience, and thank you for getting the transcript and dealing with this little quirk. Hopefully maybe the legislature can address that going forward. Thank you. Because the statute says you can't even mention the statement otherwise. So that, I don't think that's what they intended for a recorded statement for law enforcement purposes. Thank you very much, ladies and gentlemen. Thank you for your patience. As we talked, and you've seen us take sidebars and discuss matters of law out of your hearing. And you've had to leave on occasion, and sometimes it takes longer than others. Please remember something. That is very proper. Nothing wrong about what was done. It's not improper for either side to say, oh, we need the jury to be excused. That's the way this works. So thank you for your patience and indulgence. And we're ready now to continue. Thank you very much. You may resume your examination.
Mr. Warman, I've only got two questions in regards to the recorded statement. One of them we kind of already got into, but I'm going to ask it again for clarity. Have you had an opportunity to review your statement?
Yes, I did.
Okay. In regards to Stephen Schiraldi, is it true that Heather told you that, or he told you that he texted her that night up until around 3 a.m.?
Yes, sir. It says I think I said that he thinks until he fell asleep or she stopped answering.
Okay. And did Heather at any time indicate to you that she had been stalked on the internet by an individual?
No.
You don't recall that at all? You can explain your answer.
Okay. That has nothing to do with that.
Okay. Well, no, that's fine.
Okay.
Do you have any knowledge of that at all?
Her being
By
stalked
an
on
older
social
man
media?
and her having to say something about it?
No. This, can I?
Not in there, but at all?
No.
Just a general question?
No.
All right. You can put that statement away now. Nothing more to do with that. Do you recall speaking with investigator Stephen Brown back in November of 2014, roughly? He's the investigator with the solicitor's office.
I spoke to him multiple times, yes.
Okay. You aware that Heather was kicked out by Jeremy of his apartment right before she came to live with you?
Yes.
And he was abusive in the past?
In the past, yes, he was.
Do you recall seeing an Instagram picture of Heather with a broken nose and 2 black eyes?
Yes, I do, from 2012.
Do you recall Heather telling her that Jeremy was responsible for those injuries?
I do believe I said that.
Okay. Now, during the time that she had, in between the time that she broke up with Sidney and the time of her disappearance, you said that she had not officially dated anybody, correct?
Yes, sir.
Did you ever state that Heather would hook up with Jerry or Jaron,
I did.
and that she was in fact sleeping with them in November?
That would have been in December.
December, I'm sorry.
December, yes, sir.
I want to ask you if you can identify a document. I'm not sure if you can or not. If you can't, fine. But I want to ask you, this, whether in paper or on the computer, was ever shown to you by Heather?
I believe I have seen this. This is.
You just wait a minute. You can't identify that?
Yes.
I mean, you've seen it.
Yes.
Sure, yeah. Mark for the application.
This would be defense exhibit 4 for identification.
Identification. Right, very well. Thank you.
I want to hand you back what now has been marked defense exhibit 4. Can you tell me what that is?
This is a conversation between Heather and Dennis Hart Jr. That she had posted on social media.
Okay, and can you identify the portion in there which is not written text but made out to, is that somehow an emoji or a thing that people do?
It's a bunch of symbols and characters made out to be almost like a stick figure doing something that's explicit.
Ejaculating?
Correct.
Okay. And that was sent to her that's in her conversation with Stephen Hart.
Wait, what?
I mean, Dennis Hart.
Dennis Hart Jr.
And that is Dennis Hart sent it to her, not her sending it to him.
Can I see that?
It should say sent or received.
It says recipients both, and that she was the author.
Right, you're right. Okay, thank you. And that was sent to Dennis Hart.
Correct. Junior.
Junior. Okay.
Your Honor, can I ask for her to publish the entire conversation?
Yeah, I'll have her.
Completion?
Well, you'll have a chance. I mean, you can revisit this, you can redirect. But, I mean, all he's done is talk about a figure, nothing's been said. I mean, so if you want to publish it, that you may do so. Unless you want to do it for continuity. But if you're going to publish the whole thing, you're going to have to introduce it.
Possibly the last question based on the answer. Dennis Hart Sr. works at the Tilted Kill, or Junior.
They
back
both.
back in 2013 when you worked there and Heather worked there.
They both worked at the Tilted Kill.
Okay. And when you say Junior, that's the son, correct?
Correct.
In 2013, can you, and I'm in no way holding you to this, can you give me an approximate age of him, age group?
I believe he goes by DJ, but I believe he was around 19 years old.
Okay. And so could his father be in the age range 40-ish, 40, late 30s, early 40s?
I think he was a little bit older than that.
Okay. Do you know whether or not either of those individuals were registered sex offenders?
I do not.
Okay.
Your Honor, at this point, I have to object. I have no idea where this is going or how it's
I
relevant.
appreciate it, Dean, and not going any further. Overruled, I'll allow that.
I'm going to ask you, John, if you can identify a document for me, please. What that appears to be. If you can, don't tell me, but just if you can identify what that appears to be.
Your Honor,
Yeah.
can I please just see what he's showing the witness?
Well, until she identifies it, it's listed as no consequence. I mean, if you want, you can get it from him, but right now, if she doesn't see it, it goes back to them. It doesn't go anywhere. The jury doesn't see it. I just don't allow, there's no need to until it becomes something that he's going to ask questions about. That's my approach to it. I understand you may have a different approach, but that's the way I do it. But you're entitled to see it before you ask any questions.
So, do you know what that is?
I do now.
Okay. Do you recognize that photograph?
I do.
Okay. Now, hold it, please. I'd like to mark this as Defense Exhibit 5 for ID only.
Your Honor, we've already objected. I'm assuming that's on the record.
Well, you objected to him marking it as Defendant's 5.
I'm objecting to him introducing anything.
He's not, I haven't heard him try to, all I've heard thus far is mark it as Defendant's 5. He can mark it as Defendant's 5. She said, I've seen it. That's all we know. I don't know what it is.
Okay.
So, at this point, no, the objection, you object to the marking of Defendant's 5, and for ID, I overrule the objection. I think he's entitled to have it marked.
And just for the record, it was an objection for the relevance.
Well, I have 5, and for ID, I overrule the objection. I think he's entitled to have it marked.
And just for the record, it was an objection for the relevance.
Well, I